Deputy Lawyers Robert Durst. Mr. Durst is present with Mr. Chesnoff and Mr. DeGuerin. We have Mr. Lewin, Mr. Balian, Henderson, and Milius present. We're here, first order of business is a motion for a mistrial by the defense. Also, based on yesterday's conversation at the end of the day, I did in fact draft a possible instruction. I'm going to share it with you. I'll share it. What I looked for is some balance, nothing that we could possibly come up with at 4:30. So have a look. We'll discuss it after the testimony of this witness on the mistrial.
And Your Honor, we're still going to discuss before the court gives the
Oh, no. Look at it. I want your input.
Because our issue, Your Honor, is that no.
We'll discuss it. Well,
Okay.
you look at it because it's balanced. All right. Mr. Durst is present, and you have Mr. DeGuerin. You wish to make any remarks before you call a witness?
Your Honor, I'm getting the three reports in order to make sure that the prosecution has copies of all three reports, and I will mark the three reports and just briefly make some remarks. We're having some copying issues tonight, quick. And I also have a curriculum vitae of Dr. Klein. Our witness will be Dr. Keith Klein. He's in the courtroom. We can have him sworn and take the witness stand while we're getting this other
Yes.
stuff done.
Dr. Klein, please step around the counsel table and approach the witness stand to be sworn. I have medical records also from LA County USC Medical Center and Men's Central Jail. I think they should be next in order, court's exhibit, which will be 14 collectively. Oh, 15, court's 15 will be the medical records, updated medical records.
Sir, remain standing and raise your right hand to be sworn. You solemnly state that the testimony you may give and cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated in my office.
Injured your right arm, I see.
Pardon?
You injured your arm.
Yes, sir.
Oh, sorry.
My,
You may be seated.
my brother sends his regards.
Ah. Oh, very good. Thank you. Witness mentioned to me that I know his brother. So, all
I
right.
was going to bring that out in full disclosure.
Ah, very good.
Your Honor, there are
For the record, sir, please state and spell your first and last name.
Yes, sir.
Please state and spell your first and last name.
Keith Klein.
Thank you, sir.
Doctor, can you move the mic closer to you so Mr. Lewin can hear better?
Thank you.
So we all can hear better, right? My hearing's not so good either.
Mine is clearly, as demonstrated, the worst,
Okay. Stipulated.
unfortunately.
They have some of these tough ones.
Well, these are my only copies, so I won't introduce them, and I won't copy these. If the court please. Dr. Klein has written three reports. I want to make sure that the court has all three and the record has all three. The first is dated May the 12th of 2021. The second is dated June the 14th, 2021. And the third is dated July 20th, 2021. And I'd like to have those marked and submit to the court
Okay, courts 16, 17, and 18 respectively?
in that order, 16, 17, and 18.
Yes.
Those are court exhibits.
Yes.
May I submit them?
Yes. And I've read them previously.
I don't know if this is on the record, Your Honor, but just so it's clear, we have no objection to the court having reviewed those reports, or that the court is considering these reports.
Thank you. They're exhibits to written motion. So that's, I read them at the time I received the motions. All right.
I also have a curriculum vitae of Dr. Klein, which I'd mark as for the court's next.
Court's 19. And I do.
In the interest of time, Your Honor, the people will also stipulate that Dr. Klein is fully qualified, and that the defense, it's not necessary for them to qualify him as an expert. We'll stipulate to that. Hopefully save a little bit of time.
Accept that, Mr. Chestnut?
I defer, but I would say yes.
Yes.
Okay, thank you. I'll review the CV.
Your Honor, just before we start, as kind of a foundational issue, and there's authority that goes both ways on this. The authority that I've found has stated that this issue regarding the request for a mistrial is a fundamental right. Given that it's a fundamental right, a concern that we had, given what Mr. Durst has previously stated in court, in his letters, on jail calls, etc., is that we are unsure if he even supports this request for a mistrial. Now, there is a case, which is Moore at 140 Cal App 3rd 508, which says that a mistrial is a fundamental right. There is a Cal Supreme Court case, Brandon, 1995, 40 Cal 4th at 1172, that although it says mistrial is a fundamental right, it says it can be made by a defense attorney even over a defendant's objection. The problem is that when you look at other authority, it's certainly an issue that is open for interpretation. And
Very interesting. And not to interrupt you, but I'd like to, it may be significant, it may not be significant. It's a fascinating question because we now have this idea of the client control over the ultimate rights, yet a dividing line over evidentiary issues. So this is very good, but why don't you save that?
Okay,
Let
I would just
Mr. DeGuerin proceed.
All right, we'll do, Your Honor.
Well, if we can get the horse back in front of the cart.
Thank you. I appreciate that too. And I presume Mr. Durst agrees with this.
Your Honor, he does, and Mr. Durst consistently has said that he wants to testify in his own behalf. That having been said, we are very concerned as lawyers about Mr. Durst's continued declining health and how it affects not only his physical ability to withstand the rigors of testimony and cross-examination and continued trial, as well as his cognitive abilities to make the decision, balancing his right to testify over his concern of his health. Does he risk his life and health by testifying, or does he risk his liberty by not testifying because of his health?
I see. So what you're saying to me now actually makes Mr. Lewin's comment significant.
Yes, so
Because if you're telling me there's a difference of opinion, you're telling me that the lawyers are concerned for his health and think that he maybe shouldn't testify for that reason, and you're telling me he insists on testifying, and that is indeed a fundamental right.
Okay, but Your Honor, so the record is clear, and Mr. Durst will affirm it. He understands that we are seeking a mistrial, and he agrees with that. He also has an interest in testifying, but he understands the medical issues that we're attempting to offer to you are legitimate, reasonable, and he would like a mistrial. Is that right, Mr. Durst?
Yes.
Thank you. You may proceed, Mr. DeGuerin, and I took that as a segue into your, from artful segue, from question into introduction to the point you're making with this testimony, so you may conclude those remarks and question the witness.
Dr. Klein, briefly, your qualifications and your specialties.
I'm a nephrologist and an internist in active practice.
Nephrologist, NEPH? Okay, thank you.
Yeah, kidney disease, Your Honor.
And speak directly in that microphone. Of course, you're muffled a bit by the mask. We have to overcome that by having you speak right into that microphone.
Nephrology is kidney disease.
Is that a limitation on your practice, or is your practice broader than nephrology?
It's an interesting question, Mr. DeGuerin. I practice internal medicine and nephrology. Unlike when the heart fails, you have pain, lung fails, you're short of breath, you have a pulmonary doctor, a cardiologist. When the kidneys fail, the brain, the heart, the lungs, the skin, the blood, the bones all fail, which means a nephrologist has to be able to handle, to some degree, all these subspecialties, more than just what a general internist would do. It's basically the everyday practice of nephrology encompasses all these other things.
And you're associated with Cedars-Sinai and other teaching institutions and hospitals.
Cedars-Sinai and UCLA.
Your experience with patients in the jail, have you had experience in the medicine offered by the jail?
Yes, I have.
What is that?
I was at County Hospital for 17 years. For 6 years, I did internal medicine and nephrology consults on the jail ward at County Hospital. In those days, it was located on the 13th floor.
All right.
I also have lectured at several prisons around the state of California on hypertension and kidney disease in prisoners. And I've had a number of patients who've been ex-convicts. I've also had a few patients who have been prison guards, but in the federal prison system. And I have a number of patients who are judges and deputy district attorneys.
Now, have you had records of Mr. Durst, of his treatment, his hospitalizations, his medical records for going back many years? Yes.
I've reviewed the records from the Medical Clinic of Houston, Cedars-Sinai Medical Center, the Oxnard Clinic, the LA County Jail, Infirmary, and LA County USC Medical Center. It's approximately 20,000 pages in total.
So, do you feel that you have had adequate reference, adequate ability to assess Mr. Durst's medical conditions now?
To some degree, yes. All of the, I'm sorry, Your Honor, the alarm.
Remind you to be here?
Yes, sir. Yeah. In my old age, I could forget, you know. All my opinions are soundly based on the medical record, but of 20,000 pages, it's difficult to review every page. And every time you go back and you look at new things, you find actually new
Let me stop
things.
you a second. You're going to have to get that microphone closer to you and speak directly into it because your voice is muffled.
his records are so voluminous and complex, and such an enormous number of medical conditions that every time you go back in, you can literally find something new. For example, the judge kindly provided records about 48 hours ago, and in reviewing them, I found a lab test I hadn't seen before that's highly significant.
What is that?
It showed that his thyroid was very underactive. And when I saw that, I went back about 6 years, and I found his thyroid was normal 6 years ago. So clearly, his thyroid has become underactive in that period of time. People that have low thyroid or hypothyroid can have a number of conditions. The most simple one, for example, is they can have constipation, but not always so. The most severe is they can actually have slowing of their cognitive abilities. It was identified as being a low thyroid, but for some reason, it's never been further worked up, and he's not on any thyroid medicine at all. So this has been untreated and really undiagnosed.
So in addition to what I'm going to go through in a moment and what you put in your July 20th report as to an outline of his conditions, he in addition to that, he has hypothyroidism and is being untreated for that. Is that right?
Yes, sir. Yes.
And does that likewise affect his cognitive abilities?
He has literally a legion of things that can affect cognitive ability, and this is now added to it.
All right, that's my point. Let me get you, if you will, have you actually examined Mr. Durst yourself?
Yes, on 2 occasions, one at the central jail and one here in the court in a side room.
So, based on your records review of voluminous records, including the most recent, and based on your 2 examinations of this, Mr. Durst, would you please outline for us briefly each significant medical condition that he has that could affect his physical abilities to withstand trial and his cognitive abilities? Would you tell us what those conditions are?
Yes, I assume I have 8 hours.
Well, no, and I understand because I've been with you your sense of humor, and I understand that that is somewhat of a facetious remark, but nonetheless, would you just tell us what those conditions are?
Yeah, the point I was making is it will take a fair amount of time, but let me summarize them.
Please.
The first is that he has normal pressure hydrocephalus, and he had a shunt placed about 6 or 7 years ago in Texas, I think in 2014, I believe. At that time, he presented with an abnormal gait, urinary incontinence, and a degree of dementia. And an MRI showed that his brain had actually, so to speak, shrunk from the normal pressure hydrocephalus. So he was treated, and 50% of people within 6, 7, 8 years will have some sort of a relapse. This is a very, very serious condition in him. It unequivocally can cause serious cognitive defects, and just doing an MRI or X-ray to show the shunt is working is not enough. He needs to have what's called a neuropsychiatric evaluation, which is not done by a neurologist. It is not done by a psychiatrist. It's a specialty. It's a 6-hour exam. It takes 6 hours to determine if indeed he has serious cognitive defects.
All right, has he had that in the jail?
No, he's not.
All right, what's the next condition of significance?
Your Honor, if it will help, people are willing to stipulate. The court has read the reports.
No.
Well, there's no jury, so I'm just,
Okay.
I'm trying to, I know the court is interested in saving time.
I
so
am. What do
we
you
are
want to
willing-
stipulate to?
The court has read the reports.
Yes.
Said no, Judge.
May I finish my?
To what fact would you stipulate?
We will stipulate to the information that the doctor put in his reports, so that the doctor would testify to the same information, and the court can consider. In other words, What's going on now is he's just rehashing what's already in the report.
I think that this is significant because it highlights what, in his opinion and counsel's opinion, are the salient points for my consideration. So I think we'll proceed without a stipulation.
Okay,
right now.
I was just trying to help.
Okay, doctor, briefly, what are his conditions? We'll get into the effect in a moment.
There's evidence he may have a tumor in his parathyroid gland, a parathyroid adenoma. He's got the thyroid I mentioned. He has chronic lung disease, both restrictive and obstructive. He's got significant cardiac disease that is an imminent threat to his life at any time. He has esophageal gastric problems that impair his ability to absorb nutrients, such that no matter how much you feed him, you will not correct his profound malnutrition. He has kidney disease. He's got what's called a large staghorn calculus, or kidney stone, that will never pass. It cannot. It's way too big. It's by definition infected, unlike other kidney stones. So he's walking around now with an infection in his kidney. An untreated staghorn calculus will destroy that kidney. It also predisposes him to sepsis, an infection in the bloodstream. He has a distended bladder and cannot empty his urine completely. He was admitted and found to have 1,100 cc's of urine in his bladder. A person who empties his bladder shouldn't have more than 5, 10, 15 cc's. The significance of this is he presented with an infection in his bloodstream from this, and was admitted to the ICU. So that the presence of an obstruction of this degree is damaging his kidney. The staghorn calculus is damaging his kidney. He's walking around chronically infected, and he's receiving no treatment for this whatsoever. In addition, he's got osteoporosis, and he's got severe spinal disease causing possible weakness and neuropathy, and certainly a lot of pain.
All right. Do the records that you reviewed, in addition to your examination and diagnosis, do they confirm all of these diagnoses?
Absolutely. Actually, these are not really my opinions. They're all well documented repeatedly in the medical records.
I want to ask you then, and this is without explanation of each of these conditions, but I want to ask you about prognosis now under several scenarios. First, the trial continues. That's the first scenario, and the second scenario is the trial stops, is either because of mistrial or continuance, and he gets treatment. If the trial were to stop and he were to receive treatment, what treatment would he need?
He should be hospitalized immediately. If he walked into my office in the condition he is, with the medical conditions he has, I would hospitalize him today or tomorrow, and I would bring in a group of specialists, all board certified, all experienced physicians, not residents in training, not nurse practitioners, not physician assistants. I would have cardiologists, pulmonary, gastroenterologist. I would be the nephrologist. I would start him on intravenous nutrition, high potency, called total parenteral nutrition, which I would do. I ran the nutrition service for 20 years, and I'm also qualified to do that. He needs to have diagnostic studies immediately done on his heart. He's at risk of sudden death. He needs to have a urologist assist me in handling the Staghorn calculus and the urinary retention. He's at risk of sepsis and septic shock. That's what I would do today or tomorrow. Now, the
So,
trial,
Is he presently at serious risk to his health and survival?
absolutely.
Assuming the other scenario, that is that the trial continues, I want to address his ability, both physically and cognitively, to testify in his own behalf. First, physically. Given the scheduling, that is, getting up at 4 in the morning, assuming, and being transported from the jail, then being on the witness stand and being examined and cross-examined, what risk does that pose to his health?
It's a very significant risk because he's not getting treated. He's suffering the stresses of coming to court daily. He sits there in a pool of urine and often feces. He's got, I'm sure, a distended bladder. I cannot fathom how he can sit in court. But, you know, I have people come to me all the time wanting to be excused from jury duty. And my brother has always said, be very, very strict, because he hates it when doctors do that.
Your brother is a judge.
Yes, well, he's retired now.
And in full disclosure, as I mentioned earlier, your brother is, his
Clifford
name?
Klein.
Sorry?
Judge Clifford Klein.
And he's now retired.
Yes, sir. He's doing,
a wonderful judge.
he's doing mediation.
Making more than he did as a judge. So,
Well, he's also,
Don't tempt me, Mr. DeGuerin.
Your Honor,
I would cause a mistrial.
every time I call my brother, which is several times a week, he says, I can't talk to you now, I'm on the golf course. So that's.
You're killing me.
So
Please continue.
the point I was making is, if Mr. Durst came to me and said, I have to be on the jury, I think there's no way you could serve on a jury. It's impossible. If he can't serve on a jury, how can he be in a murder trial? It's inconceivable. Now, that's the physical part.
yes, now address the cognitive part. How his conditions affect his cognitive ability.
In the medical record, it describes him as being cognitively impaired or deficient many, many, many times. I can give you a stack of papers I extracted from the medical record where again and again it mentions his cognitive deficits. There's many actions he does that show that he's got cognitive deficit and he's declining. His medical conditions are definitely impacting his cognitive ability. Now, there's an interesting article published in the Washington Post about urine, and it says, it's the kidneys taking your blood and turning it into urine that allows that blood to go to your brain and turn it into thought. It's the kidney's ability to make urine that makes us human. He does not have that ability. His kidneys are producing what we call bad urine or defective urine. They're not cleaning his blood. That alone will cause cognitive defects, stamina problems. In the record, it describes him as having chronic kidney disease, CKD stage 3. There are 5 stages. He's actually stage 4. The lab values are being misinterpreted. So he's got stage 4 kidney disease. He has been told that he's going to go to stage 5 and need dialysis. So that's how severe his kidney disease, that alone can cause cognitive defects, notwithstanding the urinary tract infections, the sepsis, the lung. He's having arrhythmias, and the record documents this very well.
So, 2 questions. First, are there repeated references in the existing jail medical records about cognitive deficits.
Yes, I literally have a stack of pages almost this thick. And that's not even all the references in there
About an inch and a half to the record.
Thank you.
that repeatedly say that he has cognitive deficits. Also, there are descriptions of his behavior again and again which show that he has cognitive deficits, so that his capacity to make an informed decision is impaired. He cannot make an informed decision. So,
Can you give us some examples of what you mean by that? And also keep in mind that this case covers events for 40 years backwards, from 40 years ago. Difficult enough for someone without cognitive deficits to remember events 40 years ago. But tell us how, with Mr. Durst's conditions, that's affected.
well, I don't know that he could accurately recall events from 40 or even 10 or 5 years ago. And even if he did, I would question the accuracy of his recollection. And when I examined him, he did not know the year, for example. And he wasn't sure of the month. He couldn't recall certain basic things. Other things he could. You know, it's not an all or nothing. And he may have a good day, but he certainly can have bad days as well. But the overall slope of this is a downward decline. But you don't go down in a straight line. You have plateaus and this and that. And those plateaus can be a day or a week or a month. But nevertheless, the overall description, again and again in the record, is that he's suffering decline. And in some cases, it says rapid decline. I mean, they say it better than I do. And this is from the jailhouse records, where they observe him day to day. Not county hospital, where he may go for a day or a clinic or a 3-day admission. We're talking about people that are observing him all the time, essentially 24 hours a day, except for the time he's in court.
So are there actual examples in the jail records showing conditions that required emergency treatment, such as a 3-day visit to the intensive care unit of the hospital?
On that instance, he was found unresponsive on the floor. And he was transferred to county hospital as an emergency. And they discovered that he had a severe urinary tract obstruction and infection. He was hospitalized in the intensive care unit, where he was treated. And there, it was interesting that he was found on one occasion to have ventricular tachycardia, non-sustained, meaning it stopped itself without any specific treatment. But it was significant enough that they noted that in the chart. Now, if any one of you in this courtroom gets ventricular tachycardia that is persistent, you will die. Right here and now, you will die. He was in the ICU being monitored. It was well established. It was interesting because the cardiologist who saw him in clinic said he found no evidence of any arrhythmias, and he had 10 normal EKGs. I have brought to court 2 EKGs that are clearly abnormal, and I can display them if you want. I cannot fathom how the cardiologist could say, oh, and by the way, 10 normal EKGs over 3 years is 5 minutes of time. And arrhythmias can occur at any time. And no cardiologist would say, judge arrhythmias by an EKG. You have to monitor them for anywhere from 24 to 2 weeks, which was suggested, by the way, in the medical record.
But not done.
Pardon?
But not done.
In the medical record, in the cardiology clinics and others, it said again and again that he needs a Holter monitor as IO patch, which is prolonged monitoring. There was concern. He has...
Stop. Was that done?
No, it was not.
Can you give us some examples from the medical records of cognitive deficit?
Yes. He was found in the jail to have defecated on the floor of his cell, and he covered it with his clothing.
And
That's not considered normal behavior.
is it noted to be cognitive deficit?
That would be noted to be a cognitive deficit. They had a psychiatrist come and examine him.
Now, let me just ask some is that the only one?
No, there's other examples as well. Yes.
Could he die by testifying?
Yes.
Will testifying risk further deterioration of his health, at least?
Unequivocally, it's very stressful. My brother has said, and he was part of his judgeship was in a felony court like this. I guess you call it a felony court. He said, as soon as they walk through that door, they're under severe stress. There were actually studies done that the jurors that are not being cross-examined are under stress, it turns out, when they hear things. So being in court is going to be very, very stressful.
All right.
You should take my EKG right now, and I'm sure I'm under stress. And I didn't mean that as a joke, by the way, but there's no question that, and it's inconceivable how he could testify on his own behalf. And there's two things there. One is, he has, in the record, it documents he's got cognitive defects. So his testimony will be inherently flawed and inaccurate. You cannot trust his recall. But the second part of this is, and as I heard earlier, he wants to testify on his own behalf. But that is not an informed consent. He's not really capable of that. I'll give you an example. If any of you...
So that was going to be my next question. How do all of these things combine to affect his ability to make that decision? That is, to weigh between his liberty and testifying, or his health and not testifying.
Well, you have some really nuances there that he has to be able to understand and weigh the pros and cons of testifying, the pros and cons of his chance of liberty, the pros and cons of his chance of conviction. And these are very complex decisions he has to make. Now, if any of you have ever been to the emergency room with whatever, chest pain, stomach pain, and you're sitting there in the bed and you're in distress and you're sick and you see the flashing lights and you see the arrhythmias and you see the doctors and the nurses and they, here, sign this consent for treatment. Do you really read the fine print? You say, I'll sign anything, just give me relief. That is not an informed consent. I'm sure you agree with that. How can he possibly, given the fact that he's got normal pressure hydrocephalus, lung disease, heart disease, kidney disease, bladder disease, in pain, how can he possibly give an informed consent?
That's a rhetorical question. What is the answer?
He can't. He cannot. He's really not capable of it at this point in time. What he needs to have, Your Honor, is he needs to be hospitalized. And he needs to spend, it would probably take 2, 3, 4 weeks in the hospital to get accurate diagnoses and treatment started on his problems, along which he needs to be started on intravenous nutrition, high potency, not just a simple IV. Then he needs to be discharged to an extended care facility where he can continue to receive the treatment for at least about, I'm just going to guess 3 months. And maybe he will get better, and then he could stand trial. Now, let's just take...
All right, let me stop you right there. So bottom line, is he too sick to continue in trial?
Yes.
Is he too sick to testify?
Not only is he too sick, it's dangerous.
And is he too sick to make the decision whether to testify or not?
He's not capable. He's too sick. He cannot make that decision, no.
Ask the witness.
Your Honor, I actually do have, given that the doctor has exceeded his report, I can do it in 10 minutes.
You got 5.
Well, Your Honor, I think it's important.
You have 5 minutes. Go ahead. Start.
Doctor, you said in your May report that in essence, you did not believe that Mr. Durst was going to be able to make it through trial. Is that correct?
I didn't hear you.
In your May report, you basically said you didn't know if Mr. Durst, he was so ill that he had a limited life expectancy, and you did not know if he could survive trial, correct?
That's correct.
Would you agree, doctor, that Mr. Durst, if anything, has gotten better in terms of how he has been able to understand the proceedings and participate during the trial?
He's gotten better?
Have you watched the trial, doctor?
No, sir.
Do you know anything about the fact that Mr. Durst participates, hands notes to his attorneys, tells them to object? Is that in any way going into your decision-making process involving his competence?
I think I could better answer your question if I could read the notes, what he's writing, see his handwriting, see how much he understands about what's being said, but also what you see is a gentleman here in court. You do not see inside his body. You do not see the ravages of
Motion
his
to strike
illnesses.
is non-responsive. The remainder of the question, if I may continue, Your Honor, since I'm on limited time.
Yes.
Doctor,
Actually, I'll
Given-
let that stand, though. I'll let his comment stand.
given the diagnosis that you have now given, Mr. Durst, you would agree that in essence, you would not expect that with age, he's going to get any better, correct?
Incorrect.
So you expect that if Mr. Durst is treated, that he will get better and be in a position where he can be tried. That's what you expect.
If you look at the life tables, given his illnesses, his life expectancy, I believe, is about 3 years. However, that's with treatment, with medical treatment. Now, let's just take the kidney, for example. If we get,
Motion to strike is non-responsive,
It's
Your
not,
Honor.
it is responsive, and he's an expert
I have-
witness and
I
has
have-
the right to
I have-
explain his answer.
I have 5 minutes, and my questions are very clear. They call for a certain answer, and I need to move on to the next area.
All right. The kidney part is stricken. You may continue cross-examining the witness.
Doctor, when did you become involved in this case?
I believe it was, I think March, I'm not sure, March or April.
Now, you have a full-time paid position at Cedars, is that correct?
No, it's not correct.
Do you have a full-time practice or position at Cedars?
You said paid, I believe, didn't you?
Yes, are you not paid by Cedars?
No, I am not on salary. I'm independent.
Do you have a medical practice that you have been working full-time at during this time period?
Yes.
And, doctor, can you tell me, how much money have you been paid or billed in this case since March?
I haven't been paid yet.
That's not my question. How much have you
That
billed?
was your question.
I guess, how much have you billed, doctor?
I billed about roughly, I think, $40,000.
And does that include all of the work that you've done thus far? Or is that only, in other words, is the $40,000 what you expect to be paid in total on this case?
No, sir, I have not put my bills together for the last few weeks.
So I want you to estimate, doctor, how much, sounds like you're looking at what, $100,000 on this case?
No, I'm not.
What are you looking at? Totaling your bills approximately. How much money do you expect to bill on this case?
Oh, roughly 50,000.
$50,000, and you've seen him twice? How many hours of work is that?
You mean, you think I'm getting paid 50,000 for 2 examinations?
I'm asking how many hours of work have you put in?
Well, I said there were close to 20,000 pages.
That's not what I asked you. Again,
Divide
how many
by-
hours have you put into this case?
I'm going to tell you,
Okay?
I charge roughly 75 pages per hour. That's how I review. So if we take 20,000 pages, and let's divide it by 75, okay? Then,
Motion to strike is non-responsive.
No.
What is your hourly rate, doctor?
Wait a minute.
The judge said no, you can answer.
Yeah, I'm going to let him do the math.
Hopefully it comes out of his time, not mine, Your Honor.
it comes out to 267 hours,
So what is your hourly rate, doctor, in this case?
$500.
So you get $500 an hour. Do you make $500 an hour at your other job?
I actually could make more than that.
You could or you do make more than that?
It depends on the type of patient, whether it's Medi-Cal or Blue Cross, or and whether I'm, seeing 3-4 patients an hour or 2 an hour. Varies, but I could easily make more than $500 an hour.
Doctor, so in doing your basic math, Mr. Balian comes up with 267 hours at your price. That's $133,000.
I don't bill for every hour I spend. Now, your questions are very broad and incomplete. So when I review the records, I might find that I'm going over them again and again, and I don't necessarily charge for that time. I don't charge for phone calls. And some conferences I don't charge for. So that not every single hour I spend do I bill for.
Well, doctor, I just asked you what your billing rate is, how much per hour, and what you're going to bill for. You explained it. Would you agree that if you calc out what you just said, just for the review of the documents, you're at $133,000?
No, I disagree. You asked me what my hourly rate was, and I told you. You asked me how many hours I spent, and I told you. You're making an assumption that I'm going to bill for those hours, and that's an assumption, and it's wrong.
I think that the alarm is a friendly reminder that your cross-examination is about to end. Do you have anything
I need
else?
another minute, Your Honor.
You got it? One
I'll
minute.
wrap it up. Doctor, are you aware that back in April, Mr. Durst wrote a note to the judge because he was upset about stipulations that were done, and he accused his attorneys of having temporary insanity or collective dementia? Does that sound like somebody who doesn't know what's going on?
I think you're agreeing with me
Yes.
that he's got cognitive defects to write such a statement. Oh my God, I think you just made my case. Thank you.
I'm going to bet no, doctor, but
Excuse me,
we'll see.
when you call your attorneys, I think it's a demented, and you write a letter to the judge, which I don't think is appropriate. You think that's normal behavior? You think that's normal cognition?
What it shows is that Mr. Durst is readily engaged in his assessment of this case.
Let him do it.
I have no further questions, Your Honor.
Right? I mean, judgment might be off, but you see the letter? I mean, it is quite. The reasoning is good. The logic is good. The conclusion's wrong, but he's thinking, right? I mean, how can somebody, if he's so impaired, pen such a beautiful letter?
Well, Your Honor, I haven't actually seen the letter. I always like to look at the evidence directly before I give an opinion, but, you know, to call your attorneys, those kinds of things, is a serious lapse of judgment, I think.
Okay. All right. Redirect?
No.
Okay. Then may I excuse the witness?
Yes, Your Honor.
You're excused. Thank you, doctor.
Thank you.
And counsel, do you wish to argue the motion? Mr. DeGuerin first.
Mr. Durst is too sick to continue. He's too sick to testify. He's too sick to make the decision whether to testify. It's cruel and unusual for Mr. Durst to be put through this in his condition. You should put a stop to this.
All right, thank you, Mr. Lewin.
Very briefly, Your Honor, we don't look at this in a vacuum. They've been making motions for mistrial for a year and a half for 10 different reasons, 20 different times. So what is very clear is Mr. Durst wants a mistrial any way he can get it. Number two, Dr. Klein's opinions go to Mr. Durst's overall health. It's a lot of could happen, could affect him, might affect him. Anybody who's been in this courtroom, and it's amazing to me that Dr. Klein, who's charging by his own admission $50,000, although when you do the math it's over $100,000, has not bothered to observe the man in court. The court has had the opportunity. This is a person who's not getting worse, he's getting better. He is fully engaged. He is discussing things with his attorney. He's raising objections. He is engaged in this trial. And then finally, Your Honor, as the court's aware, what they really want is, and I think the doctor was disingenuous in his last response, completely disingenuous. His comment regarding even just his kidney stone is, it's never going to be operable, it's never going to get any better. So the court, I think the court has noticed this previously, what this is not a request for mistrial. What this really is a request for Mr. Durst to get a go home, get out of jail free card and never be tried again. And because there is no current acute situation that requires Mr. Durst to be hospitalized, we are talking about chronic conditions which may or may not get better. And again, Mr. Durst had very serious cancer in 2005. He's still here. He will probably outlive us all.
Mr. Chesnoff, did you wish to give the concluding remark?
I would like to. The people don't understand that a defense lawyer makes a request for a mistrial when they see a legal issue that would prompt that request. They're not made gratuitously. The court gets to decide. In this instance, Your Honor, for Mr. Lewin to accuse a man of being disingenuous who has told the court through his report and his testimony of his experience as a medical doctor that Mr. Durst is suffering from diseases that could cause him to die when he testifies, that do affect his cognitive ability. For Mr. Lewin to comment on that he's gotten better as an officer of the court, Your Honor, I can promise you that Mr. Durst has not gotten better, and it is much more difficult to communicate with him about the real substantive questions. The preparation has been difficult for Mr. DeGuerin and our colleagues. I think I want to say this. I thought the people of LA County elected a progressive district attorney, and I think that that progressive district attorney would probably fall down to hear a prosecutor say that the only reason that this was presented was so that Mr. Durst could not go to trial for nefarious reasons as opposed to the medical reasons. Your Honor, the jail records show that the people in the jail have recognized his decline in cognitive ability. The doctor has testified to you by a report in an open court that his cognition has been affected. It's remarkable that DA would suggest that somehow all of those records are inaccurate and that Mr. Durst is not suffering from life-threatening illnesses and from serious cognitive, I mean, I can't even believe that. It's one thing to argue against it, it's another thing to suggest that the scientific work done by the doctor, who probably reduced the bill because he himself feels so passionate about the fact that Mr. Durst should not be proceeding. And we didn't just do this now, Your Honor. We've talked to you about this before. This defendant is unable to testify because of his medical conditions. It's been established, and he is losing his right as a citizen to testify in his own defense. He'll be in a debilitated state, and I will add the following. Unless Mr. Lewin remarkably changes how he cross-examines, it will certainly be impossible for Mr. Durst to respond to that kind of cross-examination. We briefed it, we provided you with what cases we could. We distinguished a villa, at least we tried to. We found other cases that talk about it. We'd ask you, Your Honor, to really seriously consider granting the mistrial in this instance. Thank you.
Thank you. I take the motion seriously, and thus I will take it under submission. I'll be reviewing these materials that have been submitted. Now, our jurors are presumably waiting outside. The defense at the end of the day, though again I didn't really appreciate the way they went about it, it is still a legitimate request. And so I see two things going on. One is something that there is evidence presented by Mr. Chavin which I think would unnecessarily cast the defense counsel in a negative light. But on the other hand, we must take into account that Mr. Chavin is a person who legitimately, first of all, has fear, I think. Let's keep in mind this is a prosecution for killing witnesses, of which he's a very important witness. So for him to be afraid is natural. He's not only getting calls from lawyers, which are legitimate, but he's getting a call from another witness who's saying, you're going to kill our friend. Don't kill our friend, and dissuading him from testifying. So for him to separate those things, I think is more than we necessarily. He's not sophisticated in that sense. He doesn't know what's right and what's wrong. And though he, on the one hand, I think the defense would like me to draw an inference he's cooperating with the prosecution and not the defense, and in other circumstances that may be so. I want to protect the reputation of the defense lawyers, but at some point I think a consciousness of guilt instruction is possible here, and I think the legitimacy of him having guards, I think it is legitimate for him to accept security, right? But it's not the fault of the people. So this is, I gave a rough draft. I'm not attached to this language. Mr. DeGuerin, how does this compare to what you had in mind?
But you may be misperceiving.
I can give you what we had in mind.
Yes, please
Sure,
give
Mr.
it to our clerk.
You may be misperceiving what I had attempted to do yesterday, and I apologize for not asking for a sidebar to do it, but we were not asking for any kind of instruction about the security, only about Mr. Chavin's testimony about my efforts and Catherine Bain, my co-counsel's efforts, and our investigators' efforts to contact him and talk to him. That's the only thing we're asking about, and that's the only thing our requested instruction goes to. It's a lawyer's duty to, an obligation to contact pertinent witnesses, or to at least attempt to, and persistent efforts to do that are part of a lawyer's responsibilities. That's all that I've.
Okay, I know you don't want to bring up consciousness of guilt, but and certainly nothing you do can be held against Mr. Durst. And I don't know. I can only infer that what this witness Giordano did was at Mr. Durst's behest. But how do we separate this?
Well,
how does a witness separate this?
You know, the reason, yes, because we weren't asking for any kind of comment or any kind of instruction about what Susie Giordano or maybe somebody else might have done. That's completely separate from the testimony about the efforts that I made and Catherine Bain made and my office and investigators made just to contact Mr. Chavin, and he refused all of them.
Got it. So, Mr. Lewin?
Several things. Number one, the problem with this is that we stipulated and gave up Mr. Chavin coming to court. They had the transcript. They've had the transcript since 2017. This information that they are now objecting to was in the original transcript. It was in the video. It was in the transcript that they were given again. They read, signed off on it. Now they act as if, Your Honor, something of a surprise has happened in court. So here's the issue. If they were going to object, if they wanted to come to the court before this witness, there was a stipulation. They wanted to say, hey, listen, we want to have this evidence out. Here's what we would have said, and this is what the problem is. Number one, we have Bob Durst clearly attempting to influence Nick Chavin. There's no question. He does it on the phone. The first conversation they have in April is, I understand, Your Honor, but I mean, I have to.
That's right. Why be concise?
I'm doing it as quick as I can. It's a very important issue. You have Mr. Durst saying, as soon as the phone is picked up, he hasn't talked to Chavin in years.
So you're taking time for things that are not precisely relevant. The only question here is, if there's an instruction about consciousness of guilt from this, I could do that later. If there's no, the one point is to protect Mr. DeGuerin, because I heard it at the moment. I shook my head and thought to myself, this doesn't make Mr. DeGuerin look good. It makes him look unethical and nefarious, and it's not. It's fine. Now I understand why Mr. Chavin was concerned about it, but and I there's no request for a comment that he's not participating or not helping, and they can argue what they want about it. I think I should comment to protect him just as I intervene to protect you. I think that this is what they suggested is a bit long. I like my own first paragraph.
Your Honor, actually, if we have a bigger issue with the court's instruction than we do with the defense's. If the court is going to give an instruction, and again, Your Honor, if I can just finish, because I think it's important. If both sides are going to stipulate, Your Honor, to testimony coming in, and we give that up, what's not addressed?
This is not an objection. It's just to help the jurors understand that and it helps your case. He testified that they were trying to contact him and it made him nervous. That's fine. That stands.
Your Honor, then let me explain where we're going with argument. I want to make sure where we're going with argument is pretty simple. Bob Durst knew how important this information was. He communicated to Susan Giordano. He communicated it to Nick Chavin on the phone. Then we have, Your Honor, we have Nick Chavin saying that in essence, Susan Giordano is telling him, meaning Nick Chavin, that the lawyers want to speak to you. Then we have going forward, we have not just that the lawyers attempted to contact Mr. Chavin. The lawyers did the following. They attempted to contact him repeatedly. He wasn't interested. They contacted him and Kat spoke to him repeatedly. Then Mr. DeGuerin shows up at his place of business when he's made clear he doesn't want to speak to them. They contact his son, etc. Now, Your Honor, there's a point in time, and I understand the court is saying, well, there's no attempt in any way to dissuade a witness. I want to be real clear. You look at we're here trying to basically cover up. They did what they did, and we're not going to make an argument that, well, the defense in this case was trying to dissuade Mr. Chavin from testifying, but the evidence that comes out, it is what occurred, and the problem is that it goes to a real issue in this case because they're trying to say that Nick Chavin is lying, that Nick Chavin isn't truthful, that Nick Chavin's making this stuff up, and while that's coming on, and while it's taken him months to give the full story on this case, in the midst of all that, he's being intimidated by Susie Giordano, who is saying that she's being directed by the attorneys, Bob Durst, and the lawyers repeatedly showing up. So in the end, Your Honor, we would have brought Nick Chavin out here and he would have testified, and we can bring him back. I have no problem. If the defense wants to have this instruction, what ought to happen is Nick Chavin get on the stand and he can explain why it was and how he took the attempts that were being made by 4 different people. Remember, there's testimony that Dick DeGuerin asked a mutual friend, Kiki Friedman, to tell Nick to call him. Whatever his name is.
He's a significant musician.
Your Honor, this is a serious issue. So when the court is saying, oh, there was no...
Look, that's fine. I'm not going to let you attack the integrity of the lawyers. I'm going to read this first paragraph. You want to call Nick Chavin to come testify to explain that point, you can ask me for permission to do that.
When you say the first paragraph, Your Honor, so meaning that's it then?
That's it. And I'm reserving the right to give consciousness of guilt later.
Okay. Your Honor, we actually don't. If it's only the first paragraph, we're okay.
Wait.
That's it.
Hold on.
Anything else? Anything else?
Stop.
Stop. I think you're ahead.
Wait, Your Honor?
Yep.
When you say that there's nothing illegal, unethical, or improper about attorneys attempting to speak to witnesses before their testimony, this is because the attorneys should anticipate testimony and prepare for it. That'll be it.
Yes, that's it.
We're good.
Thank you.
Thank you.
All right, let's get our jurors.